no one said anything. None of the observant and maybe somewhat hectoring other wives or moms or there had anything to say about my bow tie. Maybe they just didn't look me closely enough to look wonderingly at me. So I'm here again today. Check out the bow tie. We're live on Facebook. The channel on Facebook is Nooga Radio. We're live there. In fact, all of our shows are live segments. So if you're on Facebook at Nooga Radio, just click that page and refresh it, and there the news segment has opened up live. And also on YouTube at Hot News Talk Radio, we're there. On your smartphone, we have a recommendation for you. Get the TuneIn Radio app and just make Hot News Talk Radio, Nooga Radio your favorite. And there we are, all of our live shows live worldwide, though we don't care so much for worldwide as we do right here in Hickston, right here in Chattanooga and Red Bank, Saudi Daisy, Ottawa, Tiftonia, Cleveland, Dayton, and even down in Ringgold. We have an interest in serving you there if that's where you are. And also, if you're just passing through, we're glad you're passing through Chattanooga. Drive safely, be careful, and look out for careless travelers and careless motorists. There's a story in the paper today by Tyler Jett that points out a good thing ahead. It's part of a state program to bring legal services to poor people. It is through the Access to Justice Commission created by the Tennessee Supreme Court in 2009. And the goal of that is to have poor people, they're also called low income people, to be able to connect with lawyers. Now, lawyers are a unique class of people, and they are excoriated. I was reading Jonathan Swift recently, Gulliver's Travels. They get the worst treatment by that English divine and humorist, who's a divine humorist, right? The chief of satire, which is what Gulliver's Travels is. Gulliver's Travels can be enjoyed by high school students, juniors, but there's a great deal of intelligent and caustic analysis about government and about the rich and about attorneys. So there's a quote here from Kimberly DeMint from this organization. If faith leaders are equipped with knowledge to make adequate legal referrals, people could get their hands on an attorney more quickly. She's the pro bono coordinator for the Tennessee Administrative Office of the Courts. Often, she says, talking with Tyler Jett of the newspaper, those legal issues could be more effectively addressed. Tuesday has an event at White Oak United Methodist Church. It's a very small window of time, however. It's a 2-hour time frame, 6:30 to 8:30 p.m. at the church, which is on Linden Avenue. There will be 14 attorneys there. Now, this is something, if you know a poor person who has a legal problem, make sure you check the Times Free Press story today and get the details about these 14 attorneys who will be there with help on things such as child petitions or child support, landlord-tenant disputes, and the like. Nancy Cougar is an attorney and representative for Gospel Justice Initiative. And she says, I'm really excited to see how many people we get on Tuesday. And this kind of service, I'd say, is good. It's important. And I hope you, my listener, will pass word about this event on a 2-hour event tomorrow night to anyone who is poor and needing some general counsel about a problem. There's a story at DC Clothesline I wanted to mention to you about government ownership of land. We've heard about vast swaths of the West being owned by the national power, and I mentioned this here as a way of perhaps suggesting relief for its pending bankruptcy. The federal government is facing insolvency. It's $20 trillion in debt. It has about $170 trillion in political obligations that are somewhat short of the legal claims by bondholders on its debt, right? The Treasury debt is $20 trillion, but there are $170 trillion debt total, which are political in nature. They're not necessarily legally binding debts. They're not part of the debt package of the government, which it pays back, right? It pays back principal and interest to bondholders and Treasury holders. the land out west will need to be sold to pay off this debt when the lenders come calling. But there are, according to by Max Slavo he's writing in Activist Post, but it's picked up here by DC Clothesline, which it says airs out America's laundry, airs out America's dirty laundry. The government owns 640 million acres of land, or 28% of the 2.27 billion acres of land in the United States. So about a third of the land mass is owned by Uncle Sam. Around 92% of all federally owned land is in the West. And Ballotpedia has published some numbers that the federal government owns 47% of land in 12 western states east of the Mississippi. The feds own about 4% of all the land. And it just gives some numbers about various states. 84% of Nevada is owned by the good people. They own 64.9% of Utah, 61.6% of Idaho, and about 53% of Oregon. Federally owned, though Nevada has the greatest percentage of land owned by the feds within the state. Alaska has the most land overall, because, of course, it's a much larger land mass. It's 223.8 million acres, or 61.2% of Alaska are owned by the feds. Washington State has 28.5%, Montana 29%, New Mexico 34%, Colorado 35%, Arizona 38%. California, a prosperous state if there ever were one, though greatly burdened by taxation and regulation, 45.8% of the state owned by the good people. Wyoming 48%. So this is this of course says that there are assets that the government has when it needs to sell. Now the sale of that land will drastically cut prices of surrounding land. Right now the properties surrounding or surrounded by these large swaths of territory have their market price perhaps inflated because of the mass inflation in real estate by the Fed. But when these parcels go on the block, there'll be a great reduction in the dollar value, the nominal value of land in dollars, and that's something that's going to have to happen soon. The biggest case in Tennessee in 80 years is going to be argued next Tuesday in Nashville. It's the biggest case in 80 years, a case of first impression, and it goes to the question of our interest here on the David Tulis program, and that is the free market and local economy versus its big enemy. Now, the big enemy we could summarize in two areas. National economy perhaps would be one, the debt economy, the debt corporatocracy in Washington, and the other is the state itself, the modern state that has retarded it and gotten people invested in its own claims and its own interests. People have a stake now, and they've had since the 1930s. They have a stake in inflation. They have a stake in debt. Right, the things that are bad, the government wins people to it, so that these things that are bad will have a built-in constituency. There's so many things that have a built-in constituency that are part of you could say a national financial suicide. The suicide is the self-extermination, the self-extinguishment of a country, of a nation, of a government, and that could be in the case of the National Socialists in Germany. That was a war against the world, against the East and the West. And what happened to Germany? There was nothing left of it after the Americans, the Brits, and the Russians came in on both sides, and Japan as well. An ambitious war. We need this. We need land. And we're going to take it from other people. We're going to invade other countries and expand our operations because we represent progress. We represent what's best in humankind. And we're going to liberate these people in China. We're going to liberate these people in Russia. And we Germans, we're going to come into Belgium, France, Holland, Norway, and Sweden. And we're going to bring better things to them. We'll have more land to be good on and more. And we'll have people who will help run our factories and provide new bases for taxation here in Germany. So there's always this sense of our noblesse oblige to other people whom we're going to absorb into our own culture and make subject to us, because we in the end, we will benefit them. They'll be benefited if they just join our party and agree to cooperate. And that's what the Americans have done in many areas of the economy. Now, in Tennessee, this is typical of states across the country. The Tennessee has become, in many ways, a mini Washington. It operates on the same principles. It is a financial interest, and there is an interest in the stability of the system, to have everybody cooperating with the system and agreeing with it. But there are dissenters. Now, I'm David Tulis here. Thank you for giving me just a minute of your time. I dissent from this program, and I think you, my listener, if you could just think in terms of local economy and the free market, you would maybe become a dissenter too. You might actually think that things are not right in Washington. Things are not right even in Nashville, as we've explained. And this case is State of Tennessee versus Arthur J. Hirsch. And the oral arguments are made this next Tuesday, not tomorrow, but next Tuesday in Nashville, in the Supreme Court building. And the issue is, to what extent the question is the extent of commercial government that has everybody in agreement with it, right? Everybody that you know will agree with it. Even the most conservative and Constitution-minded candidate for governor, May Beavers, is party to it and accepts it. And so there is, you might say, there's a great a cultural acceptation of commercial government, which of course means if you have commercial government, you don't have liberty. That's all there is to it. Commercial government is it's hard to say that it's tyrannical. It's hard to say that it's despotic. And so I avoid inflammatory words like that. I call it instead commercial, to identify the real method of operation, and to suggest to you that it's an impersonal thing, right? They're not trying to hurt anybody, though commercial government is a sort of fleecing operation that sustains state government, which will be a lot more limited in what it did in many other areas if it didn't have the cash flow from the commercial operation. Now, the 1937 Driver's License Act is one that created the whole world of the driver license and commerce. What it did was give the state government a platform, an ordinance, a statute that was similar to those of other states, thanks to groups such as the Uniform Law Commission, that define commerce in a vague way. Now, I say vague way because the vaguer the statute becomes, the more times you have compound terms, each with its own compound definition, the more easily the machinery of commercial government can avoid notice and avoid challenge. And that's what's happened for years now, even though in 1939, I think, was the first ruling about it. The court ruled in favor of it. And the defendant, Sullins was the defendant, was the appellant, Sullins v. Butler. In that appeal, well, maybe I've got it wrong. Maybe Sullins was the commissioner, and Butler was the defendant. But in that case, the driver, the user of the road, was told, well, we have to have driver's licenses because they're for public safety. And he didn't raise the right questions. He didn't frame the issue correctly. I think in that era, in the 1930s, it would have been impossible to frame it correctly because the state was a universal presence. It was at the heyday of the modern state. And it was impossible to see it as in enmity against the free market. And the argument was, I think, just was impossible to be made. But of course, he had an attorney representing him, so it was doubly difficult to see those issues. But his case and the other cases since, Ballinger, Booher cases, all maybe didn't ask the questions quite right. And the judges in the Court of Appeals and the Supreme Court allowed the system to continue to operate. And so 80 years now we've had commercial government that is very rich, a very rich enterprise indeed. And the man who's challenging the statute is not challenging the statute directly, but he's challenging the application of it to him. And he is not part of a class action case, of course. It's a criminal matter, not a civil appeal. But Jay Hirsch, who is known as the fiddle man of Lawrence County, Middle Tennessee, says that this statute, with its three legs of commercial government, does not apply to me who has a God-given right, a right given by God to be free and to use and have a property right in free movement. In other words, if I want to go to church, if I want to go to visit a customer, if I want to go and visit the sick at the jail, the sick at the nursing home, if I want to go and visit friends for dinner, if I'm doing favors for someone, if I'm going shopping, if I'm helping a friend out, taking him to a repair shop to have his car left, those are all things done in the private sector. That's private activity, private use of the road. I'm not making my living buying and selling the movement of people and goods for hire on the state right away, right? The public right away. The roads belong to the people. If I were, then perhaps reasonably, I would be subject to this statute and the rules of commercial government, which mean I would have to have a driver license or an operator license. I would have to have insurance on my vehicle, and I would have to have the vehicle registered with the state as an item in commerce, a thing involved in commerce. And I say, well, this is really obscure, David. Well, what has happened is the state gains authority over private activity through commerce, and it does so. It does so really through culture. Now, the whole culture is used to being under driver's license statute and Title 55 of the Tennessee Code annotated. And it's a matter of rite of passage, right, to get your driver's license, even though the young person petitioning for it is not involved in commerce at all. He's not a common carrier. He's not buying or selling the service of carrying goods and people or people for hire. That's what common carriers do. That's what commerce is. It's involved in transportation. Now, the words transportation, driver, operator, motor vehicle, these are terms in commerce. If you look carefully at the statute and the definitions, and the statute defines most terms, there are compound definitions here, so beware. But if you look at the statutory language, you can see that it applies to people in commerce, not to everybody. I have done a study that I have not yet published on the Title 55 provision that's called show on demand, the show on demand statute that's used to harass people who are private operators. Many of them are Hispanic immigrants, by the way, private users of cars, Hispanics who don't have driver licenses and who are not involved in commerce, but simply carrying their children or themselves to work, right? Carrying their children to church, themselves to work, going shopping. There are tens of thousands of people in Tennessee who don't use driver licenses and don't have them. They fear to get them. They don't want them. They don't need them. They can't afford them, right? Licensing regimes always hurt the poor. The poor are the biggest victims of this system which is by law unjustly applied to private people. And Jay Hirsch is a private person, and he's making the case, and it's an important case because he's asking the right question. And if you read Ashwander versus TVA, the judges, the high court judges in Washington explain how they decide cases. And if you ask the right question, you will get the right answer to the right question. If you ask the wrong questions in a case, you will get the right answers to the wrong questions. So the question is, do defendants ask the right questions? Generally, no. But here we have a case, the most important case in 80 years in Tennessee, ignored by everybody of whom I'm aware, that asks the right questions. And the case has many trial level plain errors that give cause for the overturning of the finding of guilt by the jury. But there are legal issues of the structure of government that are at the forefront of the case. And Jay Hirsch says the driver license system is not unconstitutional. Why? Because when it was imposed, it did not destroy any constitutionally protected God-given rights. Those rights are still there. Think about this. If the statute did destroy or abrogate a constitutional right, that statute would be unconstitutional, right? That's right. So the state has to argue that the scope is limited. It'll have to admit that the scope of that statute is limited and that it does not apply to people like you, my listener, who are not involved in buying and selling of the services of carrying people or goods for pay, for hire, which is what open carriers do, which is what transportation is all about, which is what motor vehicles are all about, which is what chauffeurs' licenses are all about, which is what driver licenses are all about. The most important case in 80 years is going to be heard next week, 8 days from now in Nashville. The most important case, I suggest. probably in a century, here in Tennessee. Now, you can count on me to report on that. I've got a story advancing the hearing, going to be appearing the next day or two, Lord willing, at Nooganomics.com, our chief sponsor. There is, by the way, a homeschool expo coming up July 21 and 22 at Camp Jordan. Make sure you put that on your calendar. The Homeschool Expo, brought to you by CS Thea.
The Tennessee Valley's news, talk, and sports leader.